Hi, guys. So, attorney Bruce Harvey, which we are now going to call YSL Ponytail, thanks to Jason Hodges, has responded to the state's response to his motion on behalf of his client, Quamarvius Nichols, motion for a mistrial and objection to mid-trial substitution of the judge. So, we're going to see what it says, you guys. And anytime you think he's making a good point, clap in the chat. Hey to everyone that showed up early. This was an impromptu stream, so good to see you. I see Casper, Drea, and Jason, all great mods in the house. Thank you so much. Martina, Classy Beats, Blue Dream, Loving, Lay Red, Roll One Up, Vibes in My Lane, ICOS Green, Roland. We got it going. It's Ramon, Kristen, Tamika. Let's get into it, you guys. So, comes now the defendant. Let me get rid of these so you guys can see. Quamarvius Nichols by and through undersigned counsel and files his reply to the state's response to our motion for all this stuff. In support thereof, Mr. Nichols shows the court as follows. The defendants were goaded into a mistrial. In Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge, Nichols adopted all motions and arguments for a mistrial as filed by co-defendants. As adopted, Nichols' first argument for mistrial was that he was goaded into moving for a mistrial. Regarding this basis for mistrial, the state has offered, guys, the state has offered only the most cursory response to Nichols and co-defendants in the state's 4-sentence response. It appears that the state has merely given the state's opinion, which is the state does not agree with the defendant's characterization of the events. The state did not proffer the state's own characterization of the events. The state did not submit facts in support of its conclusion. The state did not present any legal argument upon which the court could or should rely. Guys, we got 3 bullet points here in response to a 4-sentence response. YSL Ponytail. Bruce Harvey. Although the state's reply gave little to which Nichols can respond, Nichols replies as follows. Nichols moves his court to deem the defendant's characterization of events as accurate, inasmuch as the state did not provide any facts or evidence to the contrary. Nichols moves his court to accept the arguments as made by the defendants, because the state did not proffer any argument of its own in rebuttal. Nichols moves his court to accept all of the legal basis offered by the defendants as grounds for a mistrial, because the state did not submit any legal arguments to the contrary, or even in furtherance of their unsupported opinion. Nichols urges this court to take note of the seriousness of the defendant's motions. And we just heard Love going on about, we know we're asking you for this extraordinary remedy in relation to Shannon Stillwell's motion. Earlier today, we looked through that. I think this is way more serious, as Bruce Harvey correctly notes here. So, Nichols is urging this court to take note of the seriousness of defendant's motions, which specify in detail the events which have acted as denial of the right to a fair trial. This was followed by the state's cynically dismissive response, which seems to consider the right to a fair trial as a trifling afterthought, rather than a pillar of the criminal justice system guaranteed by the Constitution of the United States of America, the Georgia Constitution, numerous statutes, centuries of case law, and the rule of criminal procedure. The lack of regard by the state for the fundamental issue of fairness is strongly evidenced by the paucity of the state's response, and we implore this court to take notice. A fair trial is not optional, it is foundational and mandatory. A trial is not considered fair simply because the state says so with no explanation. The defendants in this case were in fact goaded into moving for a mistrial as described in their motions. This is not refuted by the state with their 4-sentence response. We move this court to grant a mistrial on that basis. Guys, I love Bruce Harvey's writing style. What do you guys think? What are you guys thinking? I see more people rolling in. Hey to Keisha. Hey to Larry. Hey to Transplanted Texan. Good to see you. Hey Shirley. Nurse Chels. Good to see you. With the YSL ponytail. And yeah, Cash Money Cass, Harvey. Allow me to retort. Johnny, or maybe it's Yanni with a Y. Y sound. Love this. He's providing F the back a poorly written motion. Tracy says, hi to Shirley. I like that you guys know each other. I really love that. And you guys are saying hi to each other here, Chelsea and Jason. Oh, I love chat communities. And then let's see what you guys are thinking of this motion. It's pretty awesome from Barbara. Straight to the point. I like it. Blue Dream. Classy Beats, that's true. Our guy Harvey has seen some things he don't play. YSL Ponytail is the OG. And then, hey to Hellraising Angel. Oh, factual lie with the spoiler. We're going to get there, but you're saying your favorite quote is comparing the length and issues. Let's see, factual lie. So, argument 2. And remember, guys, I don't remember what motion it was that we looked at, or maybe it was the motion, maybe it was a response this morning. But one of the things we looked at from the state, I think it was 9 pages. And all of it was like introduction. It was all under introduction, and then we get to conclusion. They didn't end up breaking it up anymore. They didn't say, oh, this is the legal precedent, this is the analysis, this is the argument. It just said introduction, lots of stuff, then conclusion. So here we have better structure. Thank you, Bruce Harvey. Constitutional implications and violations. In Mr. Nichols' motion for a mistrial and objection to the mid-trial substitution of the trial judge, Nichols further relied on his right to a fair trial under the 6th and 14th Amendments to the United States Constitution, as well as the concomitant provisions of the Constitution of the State of Georgia. The state responded by arguing that this claim was made and rejected in McIntyre v. State. Oh, they're going to say your case law citations are not applicable. You're doing it wrong. First, in McIntyre, the Supreme Court of Georgia specifically stated, we assume, for purposes of this appeal only, that these rights are implicated by the mid-trial substitution of judges. After assuming that constitutional rights are implicated in a mid-trial substitution of a trial, the court went on to hold that the defendant in the case had not shown that he was harmed by the substitution, and therefore, under the circumstances of that case, they probably said this in the original. So, this appeal only, the circumstances of this case. Did we see any of this language used in Love's argument? She said this case makes it fine. It says that there's no 6th or 14th Amendment violation. Look at McIntyre. Harvey says literally no. The procedure followed in the trial court does not require reversal of the judgment of conviction. The court also stated that in Georgia, the temporary absence is quite different from a recusal. The temporary absence of a trial judge without suspension of the trial is not a basis for reversal unless the complaining party shows prejudice resulting from the absence. The state's comparison of the case at bar and McIntyre is entirely unavailing. It's no good. There's nothing. In McIntyre, the trial judge's absence was to attend his grandson's funeral. Here, the trial judge is not absent for purposes of a finite leave. He was recused. In McIntyre, the court specifically took note that the trial was not suspended. Here, trial was suspended for over a month and counting. Dissimilar to McIntyre, Nichols has not been convicted and has been on trial for over 19 months prior to the permanent removal of his trial judge. Nichols' trial is the longest trial. Another reason this isn't just comparable to someone being sick for 2 weeks. Longest trial in Georgia history. And Fani tried to cite that in her own argument to bolster her argument, to not disqualify Love and Hilton. So, we can't try to argue against this and say it's no big deal. Which includes over 6 months of testimony, some of which was conducted by the later removed trial judge after motions for his recusal were filed. So after that June 12th motion filed by Doug Weinstein, testimony continued. And we've got to rewind to that. So this testimony continued after motions for his recusals were filed, which were subsequently granted. Further in McIntyre, oh my God, this case law was a bad citation, again, for another reason. In the concurring opinion, the court noted the defense's limited request for review of the previous proceedings, included no further discussion or request pertaining to the matter. In the instant case, Nichols specifically objected to the substitution of the trial judge mid-trial, and has submitted reasons why the substituted trial judge needs to be familiar with the entire record, the impracticality of this requirement, and the harm that is caused by the substituted judge's lack of familiarity with the entire record. So there's a footnote here, and it's going to cite back to the initial motion. Nichols contends that all previous proceedings in this case need to be known by any judge presiding over the case. Nichols further contends the impossibility of such as outlined in Nichols' motion and objection. And in that motion we saw, they cited Judge Whitaker herself, saying that, that kind of sounds impossible. So the state concludes by noting that in McIntyre, the court specifically referenced People v. Espinosa, a California case, in which the Supreme Court of California held that the substitution of a trial judge for the defendant's guilt phase did not violate his rights. In stark contrast, in Espinosa, the trial judge was present until after the jury reached a verdict. Oh my God. So we have a substitution mid-trial before the defense's case in chief has even started. And Love said, "Oh, look at Espinosa." Go get him, Harvey. The defendant's application for modification of the jury's sentence of death was the matter considered by the substituted judge, replacing a seriously ill judge after reviewing the transcripts of the trial proceedings which occurred before his substitution. None of these facts exist here. There's no comparison. Directed verdict and other decisions to be made by the trial judge. Guys, what do you think of Section 2? Let's do a recap of Section 2, because personally, I feel validated. You guys have seen me say, and some of you have come into my comments reassuring me, because in other videos I'm like, am I crazy? Where's the argument here? Where is Fanny's argument? Where is Love's argument? Like, this doesn't seem to be similar at all. It doesn't make sense. Something seems like it's missing. And I'll get off the stream and I'll be like, maybe I just have blinders. Maybe I just don't want to see when the state is doing something right. And I really try to be fair, really try to look at both perspectives. And I just don't see it. And then you guys will come into the comments like, no, you're not crazy. They're just making up whatever they think they need to do because they have to respond and they've got nothing to work with. So here seeing Bruce Harvey go into this case law and be like, none of these facts exist. This is not the situation at all. Like, it's very validating. It's just very validating. And he says it so well. So, Section 2 is excellent. I agree. I see Justice Matters came in here. I had already seen that this document was up. ThuggerDaily had posted it. But Justice Matters was like a second in the cusp. Like, there's a new filing, and it is good. It is good. It is hot tea, I think you used to describe it. And hey, Felicia, good to see you. Good to see you, Jess. And yes, Love wants to win at all costs. So what do we get in Argument 3? Directed verdict and other decisions to be made by the trial judge. In the state's response, the state seems to acknowledge that directed verdicts are available, but ignores the inconvenient fact that familiarity with the record is a prerequisite for the court to make that decision. Yeah, they actually tried to say it wasn't required. Neither does the state explain how the court will make other necessary decisions without being present or familiar with the record. One of the most consequential powers of the trial judge is the authority to act as the 13th juror, as the Georgia Supreme Court held in Wilkerson v. State. Even when the evidence is legally sufficient to sustain a conviction, a trial judge may grant a new trial if the verdict of the jury is contrary to the principles of justice and equity, or if the verdict is decidedly and strongly against the weight of the evidence. When properly raised in a timely motion, these grounds for a new trial, commonly known as the general grounds, require the trial judge to exercise broad discretion to sit as a 13th juror. In exercising that discretion, the trial judge must consider some of the things that she cannot when assessing the legal sufficiency of the evidence, including any conflicts in the evidence, the credibility of witnesses, and the weight of the evidence. So that's why we saw that, and that's actually something I had to learn between the streams. But when we're talking about this specific scope, when you're dealing with a directed verdict, when the judge can say, all right, I'm kind of going to steer the reins and give my verdict, even if the jury might look a different way. That's a limited scope. There's some boundaries, there's some constraints, and there's also some things that change that ordinarily aren't the case. The jury is usually the judge of a witness's credibility. But when it comes to a directed verdict, when the judge gets to exercise the discretion available to them in that limited scope, that circumstance, they actually do get to look at the credibility of witnesses, which is why we saw that point made, they weren't in the room to see and hear or look at the demeanor of certain witnesses. And Love was just kind of like, well, look at YouTube. So, Because normally that's not the case. Even appeals courts, they don't get to watch videos of the trial. They look at the record. They see the transcripts. But here, when it comes to directed verdict, the trial judge can actually look at the credibility of witnesses and assess for themselves. That's actually cool to learn. That was cool for me to learn. How can Whitaker do that here? With a trial that's got 100 days, plus if they need to look back at any of the pretrial issues as far as conflicts in the evidence and admissibility. Because a lot of that stuff happened pretrial. Even though a lot didn't. A lot of motions in limine are flying in the middle of trial here. But how is the judge going to go back and look at all that stuff? How's it going to happen? So as J. Bethel further explains in his concurrence in this Wilkerson v. State, collectively, OCGA 5520 and 5521 are commonly called the general grounds and have been referred to as the 13th juror rule by the bench and bar of the state. These rules create a weighty and long-standing power designed to provide the trial court with an opportunity to avoid an injustice. As this court has noted, the general grounds ask whether the trial judge is personally, quote, satisfied with the jury's verdict. That's cited to Manuel v. State and also Mills v. State, which described motions asserting the general grounds as an appeal to the judge's judicial conscience. The trial judges retain the strongest of discretions when reviewing motions based on the general grounds. This authority is vested in the trial court and necessarily involves questions of fact and the independent weighing of evidence. Therefore, we must decline to substitute our judgment for the judgment of the trial court. In this case, the mid-trial substituted judge did not attend over half of a year of testimony. Okay, so we have a little bit, half of a year, that's longer than some of these, 2-week trial, 5-day trial. All right. Trial thus far has not been just fact-laden testimony of custodians of records. Rather, trial has included crucial testimony which must be personally observed and experienced by jurors, including the 13th juror, the judge. Take, for example. And actually, I want to pause. So the people that are just supposed to be give testimony of records, maybe you come in and you read a report. You rely on a report. You use the report to refresh your recollection. Some witnesses, they come in and they just, try to recall what they know from their report. Even the types of witnesses that we would expect to rely on their reports in this trial, sometimes they'd come in and they wouldn't even have a report. So just wanted to highlight that part. But here we get some bullet points again. So take, for example, the testimony of a witness whose antics on the stand led to his jailing for contempt. The testimony of a witness who accused another state witness of having engaged in abuse of authority, attempts to influence witnesses, and improper sexual advances. The testimony of a purported witness to an alleged crime who testified that no such crime was in fact witnessed. The testimony of a witness who directly contradicted previous sworn statements and now testifies that those previous statements were fabricated. This trial may very well hinge on conflicts of the evidence and the credibility of witnesses. How do you reconcile this? How do you reconcile this, especially if you just look at it in text on a transcript from the court reporter? How do you assess credibility? You can catch people lying in words, don't get me wrong. But sometimes you feel like you can tell from body language. And I'm not trying to get into body language science, but the jury gets to assess body language. I think that person's lying. They look like they're lying. And the judge, for this purpose, this limited scope, a directed verdict, should also get to assess the credibility of a witness the same way that a juror can, which they cannot do if they did not see or observe these witnesses while they were giving their testimony. And not for nothing, but Judge Whitaker can't go on YouTube and watch the ex parte meeting where a sworn witness was speaking. So how's she gonna get a look at that? She can't just go to YouTube for that. And Love certainly didn't give her a way to solve that problem. This trial may very well hinge on conflicts of evidence and credibility of witnesses, as contemplated by the Georgia Supreme Court in Wilkerson. Accordingly, in this case, it is simply not possible for a judge, without personal observation of the witnesses and their testimony, to be our 13th juror. And I think this is so great, and we're just getting to page 8. And Factual Lie says page 9 is where it's really good. So, let's finish this. We'll summarize this argument, see what you guys think about argument 3. This is argument 3. Further, Nichols notes that the original 19-month trial made numerous contingent decisions addressing admissibility of evidence, the need for curative instructions, the need for severance as the case progressed, etc. The state did not dispute these facts and offered no argument. Hey, you know what's funny? Put a 1 in the chat if you've seen the state accuse the defense of, in their motion, they make no argument. They don't even dispute these facts. They don't make any arguments. They offer nothing. So here Bruce Harvey's saying the state didn't dispute these facts and offered no argument specifying how the mid-trial substituted judge could make these rulings without familiarity with the entire record and the testimony of the witnesses. So that's the end of argument 3 here regarding this directed verdict. Yeah, you guys already know. Look at all these ones. Look at all these ones. And if you think 1, also hit the like button while you're at it. But what do you guys think about argument 3? Go Bruce Harvey. Hey, Moses Dupree. Seriously, how is Love so sloppy? Like, at this point, you have to think she's throwing the case. I mean, they are arguing that she's goading for a mistrial. And I mean, think about that. If you think you're 100 days in, nobody remembers anything except Woody and these funny trial moments, maybe it would be better for you to get a second bite at the apple. But how do you get a second bite at the apple when the defense is filing motions to say that you're the one causing the mistrial? You would have to try to cause the mistrial without looking like you're causing the mistrial. So you got to fight back against it. I think she very well, I don't know. I think an ordinary prosecutor that got to this point and did some self-reflection would be like, maybe it would be good to start over, do it right, tighten it up, get rid of this cumulative testimony, keep the jurors focused, have a roadmap, clean up some of this unnecessary stuff that surprised us. But I don't know if Love thinks like that. I don't know if Love thinks like that. And yeah, Detective Gaither, there you go. It is Ramon. Missing reports. Missing reports. Bingo, no reports. And then Tebow thinks that, I'm saying it as Tebow, I think it's Tebow. So Tebow DC Salute says, the judge is going to throw this case out by the end of the week or by next week after she meets the jury or sees the state present their case one day in court. She's just going to get sick of it as soon as we start hearing the testimony and questioning again. She's going to be like, you know what, I should have called that mistrial. Let me just do it now. And then, yeah, paperwork versus body language is totally different. Totally different. Yeah, the report from the hospital. And I mean, that was a big issue too, because that was one of the issues where Adrian Love, Chief Deputy District Attorney Love, was calling Brian Steele a liar. And then let's see. Look at all the ones. Oh my God, you guys. All the ones, because we've all seen the state argue that the defense never makes arguments. And here they're getting called out for a 4-sentence reply. Mistrial Tuesday loading, One Man Deep thinks. Mikey B says she's fiending for that conviction. Yeah, I really think, an ordinary prosecutor would be like, oh my God, mistrial, but with retrial might be a good look right now. But I think Love is probably just like, I'm fine. I did nothing wrong. And then let's see, is there a new Steele motion? I wouldn't even be surprised. DWC! So I saw DWC's going live in I don't know, I think less than 2 hours at this point. When I was setting up this stream, I saw he had a live planned, so it will redirect. It's going to be more YSL conversation. Thank you for the super chat, dear Will Christian. Says, love hearing you tackle these cases. Outstanding work. That's what's up. So there is a redirect, but if you want to let the chat know what you're going to be talking about, I know it's YSL in general, but give a synopsis, let them know. We'll be taking a trip over there when the stream ends. Justice Matter says the state is used to having their way. They've never had to fight so hard. Martina, does anybody have an answer to this? All of us are asking the same thing. How would they keep it going? Would they just call Woody again? Would they do it without Woody? And then have to give this curative instruction that Doug Weinstein gave that metaphor. If you ask the jury not to think about Dumbo the flying elephant, they're going to start thinking about Dumbo the flying elephant. So how do you even instruct the jury not to do that? Because it's going to make them do exactly that. So, oh my goodness. And then Icos says, love never imagined. Judge overrule. Judge overrule would be off the case. They didn't think that far. Well, that's why they panicked and filed that random motion in limine asking the judge to order the defense to stop making so many objections to their leading questions and for the judge to stop sustaining so many of the defense's objections to their leading questions. Just a mid-trial motion in limine. So, here we go, you guys. Let's get into argument 4. I believe that will take us into where factual lie says their favorite pages. So, unfamiliarity with the record. The state appears to concede that most jurisdictions have adopted rules of procedure requiring a substituted judge to certify on the record their familiarity with the previous trial proceedings. In Georgia, this is inferred from the U.S. Constitution, including the 5th, 6th, and 14th Amendments, as well as the Georgia Constitution and its requirements for a due process and a fair trial. You know, all of these things that Love discarded as saying, there's no violation, there's no question about a fair trial here. The court's familiarity with the record is needed to make every decision, including but not limited to litigation decisions, admissibility decisions, credibility decisions, directed verdict, acting as a 13th juror, jury instructions, severance, mistrials, and more. Furthermore, logic, fundamental equity, and society's interests all support the proposition that, particularly when a defendant's liberty is at stake, the court must know what has occurred during the trial to ensure fairness and make informed legal rulings. Anything less simply does not conform with the concept of a fair trial. Lacking any cogent rationale, the state resorts to its usual slippery slope scare tactic, disingenuously claiming that accepting Mr. Nichols' arguments risks setting a precedent that would preclude mid-trial substitution of any judge in any case. Comparing the length and issues which have occurred during this trial and a normal trial is like comparing a minnow to a whale. Here, Mr. Nichols merely contends that in this case, given the unprecedented length of the trial, which Fani Willis has solidified as a footnote, so you can't just walk that back and say, oh, we don't think the length of the trial is relevant now because it hurts us. The amount of testimony which has already occurred, the need for personal observation, the vast number of deferred rulings in a various state of limbo, because Glanville just said whatever, the witnesses which were excluded from video recordings, so you can't just look at their demeanor on video, and the portions of the trial which were not recorded at all. Like those ex parte meetings. We don't know how many there were. This court cannot timely and adequately familiarize itself with the trial record and cannot suitably proceed with such familiarization. What a great paragraph to summarize all of that. Basically, it's saying it's illogical. You are willing, the state is willing to compare a minnow to a whale, to act like they're the same thing, just to win an argument disingenuously. They are willing to say these two are the same. And none of this surprises anybody in this chat, I don't believe. Put a billion nines if you think this is surprising, if you think that this is shocking for Bruce Harvey to say. All of us have been saying this. Bruce Harvey's saying it really eloquently, really nice. I like the way he's saying it. But he's saying here, where did he put that part about society? It's for the need of society too. We need a judge to be familiar with all of these things. You can't just continue and do all the things that a judge is supposed to do. No, S. Gill, it's not spamming them. So put a lot of nines if you think the state is making a better argument than Harvey. We got two of you maybe. Maybe the two of you do think that the state beats Harvey on this motion. Or I worded my question wrong. Justice Matter says they didn't think Harvey would respond to the response. He was probably, let's see what time this was submitted. 4:42. He may have had a copy of the reply electronically over the weekend. He may have seen it this morning. But he probably, a lot of it, I feel like he could have just predicted and he could have just known that this is how Love was going to respond. So Could have had it all ready to go. Or worded it quickly, because it's the same thing over and over, right? The state is ignoring the ex parte meeting. If they're addressing it, they're calling it an in-chambers meeting, as if it wasn't secret, as if it wasn't ex parte, as if there was no funny business, nothing weird about it. It's the same thing over and over. The state's just scrambling to find more case law that apparently backs them up. But it doesn't. So let's see. Yeah, so there was a motion for sealing and unsealing. So, I mean, we don't really get to know what she actually looked at, or if it was just, she could have just wanted to see one thing. It could have been a formality. But at the same time, we know she was doing something during this last week and a half time frame. If you were the judge, what would you guys prioritize doing? What would you prioritize looking at? All right, and so we will look at this right after we finish this. We got 3 more pages. We'll look at that right after. So, recess of trial. The state concedes that mid-trial recess is unusual but misses the point. Recess is the basis for a mistrial when it results in an unfair trial. The jurors have been sworn in for 9 months, and it took 10 months to seat them. The trial has been actively suspended for over a month and counting. The jury continued to hear witness testimony after the defendant's move for the trial judge's recusal. The jury cannot erase that portion of the trial. The jurors are expected to resume trial under the auspice of a new judge, as if that won't have its own implications in their mind. The jurors are expected to remember that what they heard and observed months ago. The state has offered to help familiarize this court with previous proceedings, even if that was possible. How long will that take? While the jury remains held in abeyance. Not to mention, the state has over 100 witnesses remaining. And I haven't seen an updated witness list, you guys. Unfortunately, this trial is irretrievably broken, and the jury cannot reasonably be expected to resume its role unaffected. In arguing that the recess is not disruptive, the state relies on non-precedential cases. So again, we talked about that earlier. We're like, a lot of these cases were outside of, the circuit. They were in different areas, different states. A lot of them didn't seem like they related to the situation. None of that's surprising, right? The couple of times on stream where we've looked at the story of a case, we're like, this doesn't add up. We're talking about a brief ex parte meeting about asking for an order versus a meeting with a sworn witness that was like 3 hours long. So in arguing that this recess is not disruptive, the state relies on non-precedential cases where a recess occurred during jury deliberations when a juror was in a car accident, which you can't help. Defense counsel's illness prompted a recess, and a recess based on defendant's hospitalization lasted more than 1 month. Things that you can't really help. You get sick, you get in a car accident, you're hospitalized. It happens. It doesn't happen because a judge needs to be recused. From these non-binding, off-topic anecdotes, the state somehow concludes that the recess in this instant case is not a basis for a mistrial. This is nothing more than the state's desperate attempt at misdirection. The facts in this case are entirely different from those cited by the state. In this case, the recess is a further disruption to the jury, necessitated by the recusal of the trial judge, not an accommodation to illness or injury. And then the severance issue. Once again, the state misses the point. Nichols' argument in his motion and objection was that the previous judge had repeatedly stated that Mr. Nichols' request for severance was under advisement and could become necessary at some point. This court was not present as the case has evolved and will therefore be unable to make an informed decision based on a record with which this court is unfamiliar. So wherefore, the defendant moves the court for a hearing on this motion. Argue it on the floor. On this motion for mistrial and objection to the mid-trial substitution of this trial judge. Bruce Harvey. Nicole Westmoreland. Let's show her some love. Shout out to Nicole. And she's been in the courtroom a bunch too. So I like that a lot, you guys. Oh, and then Drea. Okay, wait. So we already covered the other thing? We'll cover it again. We can go back and look at the state's response now that we've seen Bruce Harvey's response. And then Dear Woke Christian says, we're taking YSL bets tonight. The bookies are busy. Miss Kim, thank you so much for the super chat. And then also this one has the comment here that says, I can't wait for tomorrow morning to come. It's going to be like a movie. I think I'm like 80% sure I'm going to stream it, you guys. I'm like 80% sure. One of my clients has this thing where every time I make a commitment and I schedule something in advance, like their world blows up and they're like, please help, the website's down. I'm like, oh, all right, well. So sometimes I lack commitment because I know it'll trigger something that won't get in the way if I don't commit ahead of time. But we'll see. And I will absolutely be in somebody's chat somewhere, probably multiple tabs of chats, watching that all day tomorrow. I cannot wait. What are you guys saying? Yeah, so Jason's right. Show some love. Hit that like button. It's free 99. Andrea says, who can remember the incredibly slow testimony from almost a year of seating and jury briefings and BS? The state is wholly responsible for this mess. Exactly. And I really like that all of the defense attorneys, all of their different writing styles, they do keep emphasizing this point. These delays, this inconvenience, this stuff that we can't rewind is the prosecution's fault. Here's why. They had this ex parte meeting, and then we had to recuse the judge. The judge refused to recuse himself for 2 weeks and proceeded with hearings, proceeded with testimony. We had Woody continuing to testify while the jury was present, and then we continued to have hearings on, video evidence where rulings were made. And all of that just needs to be rewound. So at the very least, we could have put this thing on pause in the week of June 12th and not had to rewind and undo those things if the judge just listened to Ashley Merchant and Alex Souser when they walked in and said, we don't think you can hear this motion to recuse yourself, Judge Glanville. You're supposed to send it to another judge. And look where we are. Kiana, plus the comfort breaks. Kiana reminds us that comfort breaks cause 17 days of recess. Oh my goodness. And then what time tomorrow? So Judge Whitaker wants to start at 8:45 a.m. sharp. So Dennis Byron, who is in that courtroom frequently, says, not sure that volume of people will be able to get through security. The court only opens 15 minutes before 8:45 a.m. So maybe it will start at 9, but that's still on time. That still seems punctual, way earlier than the jury might be used to. Can you imagine being a juror for 25 days, $25 a day? And you've been usually there, like, showing up, and then you're getting dismissed early, and then you have the next day off. You're making $25 a day. But now you come back after a break, your life's been on hold, and now you got to be there 8:45 till 5:30, 6 p.m. every day for the same $25. For the same $25. Now, that calendar management could have had this case condensed down, and they could have been done. They could have had jury deliberations. The case could have been closed with someone properly managing the court calendar and a state that had a better strategy for presenting their evidence without all this cumulative fluff. But still, $25 a day. And they're used to working partial days. And now they have to come in full time because this trial needs to get itself together after how off track it's been. That's just crazy to think about. And then let's see. Yeah, are there any new motions since? Let me just hop over and look. Anything more recent than this one? Oh, so there's an amended version? Well, let me pull this up. So this was about the state's response to what? Okay, so in the state's response to Nichols' motion, what's this amendment to? Let's see what this is. So amendment and supplement to state's motion to compel defendants' compliance with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed. I wonder if they're going to fix the issue where they mischaracterize when the defense needs to turn things over. Let's see. Let me get to these super chats. So Yolanda, thanks for the $1.99. State needs to focus less on color matching outfits. Yeah, some of those days it definitely seemed like they had to be coordinating. And then Miss Kims, you don't need to worry about a a misspelling. Free thug. Free thig. Wouldn't it be funny if someone comes along, we can make their initials THIG? But we'll look at this one. I think this is the only... If you guys see any other motions come in, besides this one, this was an amendment that Joseph Bapp put in a reply 28 minutes ago to something he posted 8 hours ago. So if you guys are looking for that document link, if you don't have it already, there's that. This is what's on the screen right now. That way, you guys, if I know Transplanted Texan says she's stacking up all the different motions. I don't have this in the description yet. I'll have to update it after the video's done. Hit the like button, you guys. And let's see what this says. Let's see what this says. The state of Georgia by and through Fonnie T. Willis, District Attorney for the Atlanta Judicial Circuit, hereby moves this honorable court for relief regarding material. So let me see. Let me see if Joseph says that. I don't want to read the whole thing, if only some of it was amended. Right? So this intro is pretty much the same, but I think this next 6 pages is all going to be about the supplemental argument. So why did we file this if we're going to add like 6 new pages of stuff? Let's just read through it, you guys. So the state's correcting and supplementing. Supplemental argument and legal authority, material at issue. Defense has acknowledged that it has intentionally withheld materials and is in possession of materials, but have not turned them over through discovery. For example, one of the state's witnesses is Adrian Bean, whom the state's evidence shows was a co-conspirator with defendant Williams in an intrinsic armed robbery. The weekend before the day cross-examination of Bean was to begin, counsel for defendant Williams disclosed a recording of Bean, which had been in counsel's possession since January 2023, in which Bean claimed that the defendant Williams was never involved in the armed robbery, and in which Bean claimed that the police told Bean to put defendant Williams in the crime. Defendant Williams presented this statement to not simply as impeachment evidence, but as substantive evidence. Further, based upon information provided by Bean to the state, the recording was only a portion of the recorded statement at issue. The failure to present that recording timely prevented the state from obtaining a complete copy of the recording, which appears no longer to exist. Such the statement cannot now be considered in its entirety. Oh, do we have a rule of completeness issue? Where someone only got some stuff in, like the specific lyrics they want to share and ask a witness about? Are we taking issue with completeness? Adrian Love. For another example, defendant Williams has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts, "We killed Nutt," referring to Donovan Thomas. Copeland is the state's witness whose testimony currently is ongoing. Why is it ongoing? The defense has not provided the state with such recording or made it available to the state, despite specific and direct requests for it. The state assumes defendant Williams intends to use the recording, if it exists, not simply for impeachment purposes, but as substantive evidence. Given defendant's explicit and deliberate decisions to withhold the materials specifically mentioned above, the state suspects defendants possess additional materials which they would submit through cross-examination, which they would want the jury to consider as substantive evidence. Georgia discovery. A defendant's pretrial discovery responsibilities extend generally to materials which are within the possession, custody, or control of the defendant, and which the defendant intends to introduce as evidence in the defense's case in chief or rebuttal at the trial. These responsibilities also extend to reports. So we're also mad about non-disclosure of reports. Someone like ask Max Shart if he's okay after reading this. These responsibilities also extend to reports of any physical or mental examinations and scientific tests or experiments, among other materials, if the defendants intend to introduce in evidence in the defense case in chief or rebuttal the results of the physical or mental examination or scientific test or experiment. So, what are we... Is this supposed to be pertinent to this? How does a report relate to a video that Steele says he has? Am I missing something? Or is this tying to Adrian Bean? Or like a hospital report? Why don't they specify here? Why don't they specify here what they want? They're just quoting something, but not saying what it pertains to. But okay. Use of inconsistent statements as substantive evidence. In Georgia, a prior inconsistent statement of a witness, we know Love and Hilton don't understand the difference between inconsistent statements, contradictions, and how impeachment by either of those two things actually works. In Georgia, a prior inconsistent statement of a witness who takes a stand and is subject to cross-examination is admissible as substantive evidence. While Georgia's discovery law does not explicitly apply OCGA 1716-4C to evidence used simply for the purpose of impeachment, it unquestionably applies to that second intended purpose, that is, use as substantive evidence. Relevant similar federal laws. As with Georgia law, federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control, where the defendant intends to use the item in the defendant's case in chief at trial. Although this does not apply to simple impeachment evidence, a defendant's case in chief does apply to evidence which is offered both as impeachment evidence and as substantive evidence of innocence. For example, in United States v. Young, the Fourth Circuit affirmed a district court's curative action against the defense in a criminal case for failing to turn over a tape of a government's witness, which the defense sought to introduce during cross-examination as both impeachment evidence and as substantive evidence of innocence. See also United States v. Waddell. I think this is actually carried over. I think we saw the same in the original filing. Denying government's motion for reciprocal discovery of tapes based on defense's representations that it did not have them, but admonishing that if he's lying about actual if not constructive possession or controlling of the recordings and later tries to introduce them during his case in chief, that evidence will be subject to exclusion. The federal discovery rules for civil cases specifically exempts from discovery evidence where a party's use of it would be solely for impeachment. Similar to what Young said about the rules for criminal cases, this requires the discovery of material which is meant for both impeachment and substantive purposes. As one set of commentators have said. Wait, hold on. Are we going to get the... Okay, so we're getting cited to a book here. If a party plans to testify to one version of the facts and the opponent has evidence supporting a different version of the facts, the opponent's evidence will tend to impeach the party by contradiction. But if discovery of this kind of evidence is not permitted, the discovery rules might as well be repealed. Even those who have been most concerned about protecting impeachment material recognize that substantive evidence must be subject to discovery, even though it also tends to contradict evidence of the discovering party. And then they're citing here by Charles Allen Wright and Arthur Miller, Federal Practice and Procedure, 3rd edition. Conclusion and request for relief. Evidence to be offered as substantive evidence is subject to discovery, even if it is introduced through cross-examination, and even if it has impeachment value. While some such evidence is developed or acquired close in time to such cross-examination, here the defense is intentionally and deliberately withholding such evidence long after it was acquired. The state recognizes that both Georgia and federal authority instruct that courts employ the least extreme sanction to remedy discovery violations. The state has moved this honorable court to exclude any evidence the defense holds in its possession in violation of OCGA 1716-4. Should the court deem exclusion a remedy that is too extreme? So we want the worst, even though we're reminding ourselves here that the Georgia and federal authority want the courts to go the least extreme route. But we're asking for the most extreme. But if you don't give us that, then we hope you issue an order directing defendants to permit the state to inspect and copy any and all material a defendant possesses, which the defendant intends to admit as substantive evidence, even if the material is also impeaching of a witness, and directing that where the proffering defendant intentionally withholds such material, that it be admitted, if at all, solely as impeachment evidence and with a limiting instruction prohibiting the jury from considering it as substantive evidence. Respectfully submitted, Adrian Love. So, there we go. This, I actually think, my bigger question here is, how do you exclude something that maybe one defense attorney knew about, but once it's disclosed or known about, it could help other defendants? Can you exclude it at the expense of the other defendants if they also didn't know until the state found out? Like, that's just because we're dealing with we have enjoined defendants here. I don't really know how that reconciles, and that like screwed with me to think about while we were reading the states before they amended it here, the initial filing. So I don't know. That's like such a huge gray area to me on what they would do with something like that. But what do you guys think about the amendment? That one paragraph was like the exact same, but some of the other stuff was like, it's okay to file a supplement and add stuff, but we still had one paragraph where where was it? They just like didn't explain why it was relevant. We're giving Georgia discovery here, but why aren't we tying this into a specific ask? Cool, there's this thing that exists. We know that this OCGA 1716-4C means that discovery obligations extend to reports of any physical or mental examinations and of scientific tests or experiments. Well, what do you believe that is of such nature that the defense is aware of and has in their possession that fits this criteria that they haven't turned over to you? Is this just broad? Or is there actually a specific issue? Because the argument started by saying they knowingly, basically we know they have something and they're not turning it over. And then it changes to some broad, all of these things, but we're not specifying what. I don't know, some of it just seems weird to me. But you know me. Yeah, I mean, it could just be the copy pasta in court filings. No footnote, no nothing. And then like they like to use footnotes for random things too. They could have just put a footnote like, this is in reference to our request for something Brian Steele referenced but never disclosed to us. He says he has it. Well, just tell us what it is. And then thanks to Kiana and Annie both for becoming members. Make sure you pick your Mario Kart racer. You guys can race in the chat. Judge Granville has met Casper the Ghost. I like this relationship. I like how that's going. Well, let me switch, because the comments look kind of weird. I changed the way the comments display, but it's kind of just blending in with the documents. So I'm going to switch that style back. Judge Granville says, DA Love set me up. I will be writing a book on this case after they find Thug not guilty. That's what's up. We're all going to read it. I'll put an Amazon link to your book in our descriptions for these videos. And then let's see. The DA's interns haven't slept for days. Yeah, I mean, I think it's got to be about Bean, but they mentioned Bean earlier in the motion. Why wouldn't they, like, tie that together? That's confusing to me. Like, why wouldn't they just connect the dot? As previously referenced, witness Adrian Bean, was apparently hospitalized on the 13th of whatever month that was, April 13th or something. And blah, 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 blah. But, this is a report. And OCGA says they should have disclosed this to us as part of discovery, and they didn't do it. Like, that would be a coherent, it would follow, there'd be A to Z to their argument, and I just don't. Oh my gosh. And then Tasha. So Steele did say in open court they had some type of evidence that he wasn't turning over because he didn't have to. He said that to Glanville. And that's why I think Love is raising this issue. But she's trying to make it seem both. I don't know if I can make sense of it, except to say that it just seems very Love. She's making it both multiple things, and we need it to just be broad and encompassing. But also she's referenced one thing that Steele knowingly is withholding. So she doesn't even know her clear messaging here. What is her actual argument? Are you angry about this one thing? Or are you asking, maybe you want to use this one thing as leverage to get some big all-encompassing order in your favor? Something that a judge would have granted if it was Judge Glanville, but probably not a different judge that, hey, if you're asking for one specific thing, maybe I'll grant you that. But I can't just grant in advance in order for the defense to disclose things that they're hiding from you if you have no grounds, no basis to believe that they're hiding something from you. So if you have one thing you think they're hiding, we can address that one thing. But Love is just like, give us everything that they may have and make sure they're in trouble, even if it's not actually, we don't actually know for sure that they're withholding anything from us. It just seems like arguing with somebody difficult, hard-headed. She'll explain it later. Oh yeah, you guys got to come up with the titles for Judge Granville, because it's Judge Granville in the chat. Judge Granville's book. Well, you know what? Sometimes drunk uncles can be funny. They have stories to tell, but if the state here is the rambling drunk uncle at the Thanksgiving, it's bedtime. Oh, that's a good point. So maybe that report could be related to Woody, but why wouldn't the state have... It's so weird to me because the state is the one that has subpoena power. They have extra resources to go and investigate these things. And they've been investigating these people. Not just like the defendant and then they learn someone new is in the picture and it surprises them. They've known who all these people are. I mean, they gave Bean a plea. They clearly investigated Bean in some capacity. They know who Woody is. He's been in the system. Like, they had to have looked at him and decided not to indict him as some type of co-conspirator under this. Like, they've had years of looking at these different people and they have the power to subpoena stuff. So if there is a report that they want their hands on, that's confusing to me. Unless maybe it's like they don't know who the report belongs to and it's been referenced. I don't know. You're right, factual love. I expect too much. It's factual lie. Oh my god, I just called you factual love. There is no such thing as factual love. Oh, that was a bad switch up there. And then, exactly, what about the state withholding reports from the officers that they're having testimony from? Like, it's weird because usually the problem is, if it's not in the report, then it doesn't exist. You see that argument made, and it can work in either direction for either side, depending on who wants to make the argument. But rarely is it, oh, I did this research and I found it and I'm testifying on all of this. Well, but it's not in your report though. And one of the witnesses said that they knew it because of their report and their notes and then didn't have the notes. And it's just like, how do you even allow that reference? To me, and you know, we're looking at this, but if you were a juror, like, everybody think about before you got interested in following this case or any case that you followed, however long you've been interested in true crime, law, any of that stuff. Before you started paying attention, whenever you got into it, if you were a juror back in the day and you heard someone talking about their report, doesn't that just seem inherently more academic, more scientific in its approach, more credible? So when you've got people on the stand trying to reference things in reports, but then the reports aren't actually disclosed, and then we find out sometimes they don't even exist, they weren't kept, or maybe they never existed, how do we even know? But we have suspicions now because we're watching stuff like this play out. But what about before you got into this, if you heard someone talking about their report, you would seem like they did more work to come to the conclusions that they had. And if those conclusions are being tied to a report that doesn't exist, that seems just inherently unfair. Super, super unfair. Yeah, and that's true too. So withholding transcripts and reports is wild because we had that 2-week hold on that transcript, but ultimately, and we've seen it argued, Glanville had to release that. We've seen the prosecution start defending Glanville at this point. We've seen it in the recent motions. And you guys predicted it. You guys said, look, we think he released that transcript because he had to. Because if he releases it, he can say, well, it wasn't kept from anybody anymore. And we've seen in the Fani motion and in the motion from Love, written by Love, well, there's no issue with it because it was recorded, it was transcribed, and we've even given the defense the transcript of the meeting. And we're just going to ignore Bruce Harvey pointing out that the transcript's not complete. We're going to ignore all of that. So, and then Heart of Inspiration, good to see you. I know you just launched a course. Hope your course is going well. If you want to, and you don't, I'll look for it. You don't need to super chat to send it again. If you want to let us know what your course is about, if you want us to tell the chat, type a comment, don't super chat it, and I'll let them know. So Heart of Inspiration has a channel where, like, really inspirational stuff, but she wants to start a law and crime, like a true crime type of channel also. So Heart of Inspiration is great to subscribe to. When she creates her new channel, we're going to support that too. But I know you just launched a course. Tell us what it's about so we can talk about it. And no problem at all. Thank you guys for being in here. I have no problem coming in here and chatting with you guys. You guys make me feel like I'm not crazy when I'm looking at this stuff, like, wait a minute. I don't know. So Drea says, I wonder if Gaither being under investigation is the reason why she has no access, quote, no access to her reports. I don't know. Sometimes I do like to conclude that the explanation for something is the simple one, like incompetence, not caring, not being qualified, not really, maybe even thinking you're so good at what you do that you don't care about your own ignorance, so you don't even think you need to take notes. You can pull like a Nathan Wade and keep all your work product in your head. Like when you're investigating Cobb County prisons for $550 an hour. The best work you got to deliver is the notes you can keep in your head. Like, it could just be a simple explanation like that, why Gaither has no reports. It could be more intentional and malicious. Either way you look at it, it's not a satisfactory excuse by any means. Like, that's it. Like, it's just not satisfactory. And yeah, so Mikey B, yeah, but isn't that way too much information to keep in your head? Yeah. And I'm going to double check again. I think, we're past the 6:30. Now, give me a second because I'll pull up. Let me go to the docket and look and see if we've got anything new. Because this is about the time of day where if something was filed and was going to be available today, we're winding down. It would have popped up by now. Can you imagine if the state filed, like, I'm not going to criticize if a response comes in, right? A response is not part of that Tuesday deadline. But on Friday, we saw the state filed a motion, new motion, not a response, a motion, which should have been filed by the Tuesday deadline. Can you imagine if we get a filing at like 11:22 tonight and it's a new motion from the state and arguments are tomorrow? Like, Judge Whitaker would be sitting there probably like ready to launch at Love if that happens. But I feel like Love would be stupid and do something like that anyway. And then, okay, so Heart of Inspiration, it was an AI 101 workshop. Oh, that's cool. Like, are you teaching people how to use like AI tools? I'll let you know the next thing I'll doing, but I'm always helping entrepreneurs start there. But yeah, so you're probably using like how to use AI tools, ChatGPT to, speed things up, make tasks more efficient. That's really awesome. I mean, guys, if you are running small businesses, I wouldn't say do everything with AI, and I'm sure that's not what Heart of Inspiration is teaching, right? The core of any business is you, your personality, your brand, right? And if you rely 100% on AI, nobody's going to want to buy your thing from a robot, unless the robot's really funny. But when you know how to use AI tools to streamline certain things, automate things, create standard operating procedures, tidy up things that you get writer's block with, super, super powerful stuff. So that's an awesome, awesome course. If we haven't dropped her link, I'm going to pull it up. That way we can get it in there. And I'll make a community post with your course too, if you want, or your upcoming course. Okay, so this is Heart of Inspiration's YouTube channel. I just dropped that in the chat. Buy beer from Bender, like Futurama Bender. All right, so if we look at this docket, what do we got here? And remember, this is the stupid portal, but it's like an easy way to see a page. Oh, there's a proposed witness list? Hold on. Brian Steele's responding to, so where's the witness list? All right. This must be the addendum and supplement that we got. Let's double check. We may have to do some, okay. We do have some new stuff, you guys. Renewed motion for all Brady evidence to be provided instantly. So is this is... Guys! Okay, this is only like 2 pages. Oh my god, that's hilarious. Let me see if it's up in full. Oh my gosh. Let me see if I've got it, because I think ThuggerDaily might also be able to access that, but if I don't have to bug him, I'd rather not. Or her. I don't know for sure. But I just think it's really funny that we have, Love is like reciprocal discovery, and Brian Steele is like responding with Brady evidence. Like, Brady evidence is a bit more important than just general discovery. Okay, so give me a moment, you guys. And thank you so much, Heart of Inspiration. Aw, guys, if you got a gift membership, one, make sure you say thank you. Even if you didn't get a membership, show Heart of Inspiration some love, because that's so nice of her to do. If you want to be able to receive gift memberships, you do have to enable the setting at least one time anywhere on YouTube. You don't need to do it just because you're watching a new channel, but you have to click that money symbol where you chat, click the little setting option, and turn on the option to receive gifted memberships. You won't get charged when it's time to renew. It'll ask you if you want to pay to renew and continue being a member. So when you get gifted something, it's totally risk-free, totally an awesome thing that, it's so nice that Heart of Inspiration did that. If you are now a member, on this channel, we have Mario Kart emojis until I update the emojis and change them to something else. So choose your racer. They are the classic retro Mario Kart characters. And then Chris Gloss, thank you so much. So Chris Gloss says, Kat, you're the best, pure inspiration. That's so nice of you. Thank you so much. I'm in this docket. Let's see if we can find this little 2-pager thing. I'm working on another screen rather than the one that's shown on the screen, but I am looking, I promise. All right. So I don't see it. Let me ask ThuggerDaily to send over. We're going to look at, this response to the witness list. We can read this here. This is like all of it. But I'm going to ask him for it's a couple pages about the Brady. We're still yelling about Brady. So this short one here, we're only going to read some of it. We're not going to pull the document. ThuggerDaily said he's not even going to tweet it because it's not interesting. But it's response to the state's proposed witness list. And, Mr. Williams is innocent of all charges. Make this bigger. And is there a way I can open this in a new tab, make it bigger for you guys? There we go. On Friday, July 26th, the prosecution provided a witness list with an attachment declaring exhibits. So they did turn in a witness list, and it was late. It was supposed to be handed in on Tuesday. So they provided a witness list with attachments declaring exhibits. The purported exhibits simply state generalities such as text messages, photographs, jail calls, and the like. The general description of exhibits does not help clarify for Mr. Williams what specific text messages, photographs, jail calls, or the like are being sought admission before the jury. Without specificity, objections will be made contemporaneously when the state attempts to introduce the same. However, if the goal is to provide notice of the party, because again, the purpose is can we trim out these arguments about evidence, get caught up? We shouldn't be having arguments about evidence in the middle of trial unless there's a reason for it. So we need you to do this amended witness list and evidence list. Get it together, state. And now Steele is saying this is like a vague line item list of what exhibits they want to enter. So I really don't think the second page of this is going to say all that much. But are you guys surprised by that at all? Are you guys surprised? I absolutely am not surprised. And then I'm sure you guys aren't either. And thank you guys so much for showing some appreciation. Long Little Meat Sack is showing appreciation for Heart of Inspiration. I love that. I love that you have hot dogs as your picture. Frankfurters, beef Frankfurters. And then Andrew's showing love. Dell is showing love. Good to see you, Dell. Anthony's showing love. Like, you guys, that's so nice of you. So I appreciate your Heart of Inspiration, and I'm so glad that the chat is being so nice. And then, what do we got? My sighing. My sighing is a telltale sign that something doesn't make sense. All right, so Moses thinks the judge is going to dismiss tomorrow. Let me take this banner down because we're not reading that anymore. And then Anthony says, I'm shocked Love is in a position such as hers, because yeah, that's Chief Deputy District Attorney, and performing like she's first year out of law school. Don't get me started on Granville or the what if has happened in prior cases. You know, optimistically, I do want to believe that maybe this case cracked Judge Glanville, right? It would be a bit comforting if we find out that this was it. Like, Glanville lost it, he was done with it, he was tired of it, and maybe he didn't do this in previous cases. Because if he did this in previous cases, how do you fix that? I feel like appeals courts are reluctant to fix things in general, let alone because someone might have done something wrong in one case and now we want to look at all the other cases. Logically, morally, ethically, we do want to do that. But practically, I feel like appeals courts, they don't want to re-adjudicate stuff like that. And it's like, how do you fix it? How do you fix it? And the risk of not fixing it is someone's losing their liberty. In some cases, you know, I don't know if Glanville sat like death penalty cases because Georgia's a death penalty state. But in some cases, that could mean someone's sitting on like death row and they had a bad judge or bad prosecutor. And that bad prosecutor gets booted off because of another case. But they can linger and drag their feet on trying to revisit the other cases that they had that went into a conviction. And it's just, you know. And then appeals take so long too. So even if like, yeah, we're going to look into it and they do come to a positive resolution, like, yeah, we found more corruption, we're going to reverse this. That could take 2, 3, 4, 5 years. Marcellus Williams, convicted by a jailbird statement, who said, oh, he told me he did this and he wanted a $5,000 cash reward. He lied. Well, there's no basis for him to think that he really had factual information. But now there's been evidence for close to a decade that exonerates Marcellus Williams. And he's finally, for the first time, getting a court to look at that DNA evidence next month. Just 1 month away from when he's slated to be killed. Like, think about how the reversal of a mistake, how long that takes. And in a death penalty case, you can't reverse that. In the case of someone who was incarcerated but maintained their innocence, but dies in prison, they can't get out and get their life back. Like, it just, I'm going on a rant, but it always pisses me off. So Kelly Doyen, thanks so much for the super sticker. That's so nice of you. And then let me see. I love the glamour shot. I love the glamour shot. I need to grow some hair out so I can do a glamour shot. I love that so much. And Julie, I just see you hopping in. I haven't seen you yet. So good to see you and Red Bunny and Yolanda. And we've got, thanks to ThuggerDaily. Guys, ThuggerDaily just sent this over. He could be hanging out, relaxing. I just dropped his CashApp tag if you want to show some love. But he sent over this Brady motion. So, this is Brian Steele, Keith Adams. Yeah, Brian Steele, Keith Adams, real short, but I really love the idea that this is coming on the tails of Adrian Love kind of throwing a fit about like, oh, they didn't disclose evidence. We know they're withholding from us. Renewed motion for all Brady evidence to be provided now. Instanter. Comes now motion for all Brady evidence to be, comes now Mr. Jeffrey Williams, by and through undersigned counsel, files this renewed motion for all Brady evidence to be provided instanter in the above referenced case. In support of this motion, you know, Mr. Williams is innocent of all charges. Mr. Williams has, from the inception of this case, demanded the prosecution to fulfill its duty under Brady v. Maryland. Under Brady v. Maryland, Supra, and its progeny, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the non-disclosure is material to either guilt or to punishment, irrespective of the good faith or the bad faith of the prosecutor. Deal is funny. This includes the suppression of impeachment evidence that may be used to challenge the credibility of any witness. Mr. Williams has demanded Brady evidence to be provided instanter. Mr. Williams again asks this honorable court to order the prosecution to provide all non-disclosed Brady evidence. It's been proven that Lawyer Love and or Lawyer Hilton have not provided Brady evidence and have, in fact, attempted to hide the same from undersigned counsel. So, ex parte transcript. Wherefore, we request that we hold a hearing on this motion and at the conclusion of same, ask this honorable court to grant the above requested relief and order the prosecution under penalty of a mistrial if the evidence has not been turned over to undersigned counsel. So we still want some Brady stuff. There's stuff that you didn't disclose that isn't in this transcript. We want you to disclose it. And the remedy, because you always say we don't ask for a remedy. We want you to order this under penalty of a mistrial. Guys, I really love that this comes on the heels of that other motion. And okay, so the point is with Brady, you guys, Brady disclosures have to happen. They could be an extreme issue, even if it's a good, you're trying to do your job in good faith, but you fail to disclose something. It doesn't matter. It's still a violation of Brady if you don't turn something over, no matter, you could be like 100% good faith. But the fact that he spelled that segment out, it's not a segment that's not part of Brady. It is a Brady thing. But the fact that he included it for the sake of including it, to me, seems like a dig. So, I'll take it. I'll embrace it. And yeah, you're right. So, okay, this is scrolling pretty fast. Someone just said they still haven't contested bond, and my screen jumped. So where was that? Yeah, let's talk about that. Yeah, hit that like button. Thanks, Julie. And then let's see. Southern accents are friendly and inviting, I think. I think they're very comforting. Like, if I'm going to a diner up north and the waitress has a Southern accent, I'm asking her what I should order. I'm just doing it because I know. I already know they're going to know the best thing there. So, let's see. Yeah, the honorable Twitter account of ThuggerDaily. We've got to all start saying that. That's hilarious. And then, there we go. Ashley. So they still haven't contested bond. I'm sure that will be something that the state doesn't see as a priority. They don't even care that these people are locked up. They don't care about speedy trial. They don't care about due process. They think this long pause is, they're saying it's the fault of the defense somehow. But part of me thinks that they really believe that in their head. I think Love actually believes that. I actually think Hilton's relieved that Love is writing all of this, that she's not having to write any of this stuff. But yeah. Because Florida, we have so many like upstate, Northeast, New York accents because we all moved down here. We all snowbird and moved down here. So we have Florida accents, but there's just so many people in Florida that aren't from Florida that if you go out somewhere normal, like a neutral watering hole, you're not going to hear that many Florida accents. You'll hear a lot more New Englanders and New Yorkers. And then, where are we? So, and that's true. Great point. So, Kiana, go to the Panhandle. Absolutely. Really anywhere closer to like the Georgia-Florida line or closer to like Alabama, you'll get more of the accents. Because I think a lot of us, we moved down, we want to move on the coast, maybe to Tampa, I guess, but a lot of the coastal areas or Orlando. Oh, sweet. So just so you guys know, and actually maybe Dre has already shared it, but that's so great. So let's do this. So you may have already shared it, Drea. The link I just shared right now is ThuggerDaily's document drive for, I think, all of these motions recently. Right? Maybe like the last, I see 617. Looks like stuff going back through June. So you're not going to get overwhelmed by documents from the whole case, you guys. It's more concise than that. But it is really helpful if you want to revisit the stuff that's going on right now. That Google Drive link is everything that ThuggerDaily just uploaded, and it looks like it goes for 2 months of time. So there you go. Wait, like Florida instead of Florida? Or like, I don't know, like the Peter Griffin way? And then Tamika says, I thought that the detectives never produced the interview from Bean at the hospital. That means they are arguing that Bean was at the hospital. They are so confusing. They don't know what's going on. And it's like they're people. They're the ones that have the resources. Like, so these defendants have money and powerful attorneys that know what they're doing. Like, One of the big talking points during the Fonnie Willis disqualification was how Ashley Merchant was so dedicated in pulling receipts, going and looking through the public records, requesting public records, looking at the receipts. That's a skill. Being a researcher is a skill. And that type of research, you have to have the bandwidth to do it. As someone trying to privately retain an attorney, you have to have money to pay the attorney and the team that they think is going to be necessary to make your defense. That might not be a question for young Thug. But think of a random person who doesn't have a private investigator budget. Like, can't go and hire someone that has a whole in-office team that will go and research stuff like this. It's stuff that the state should be looking into anyway. They have the resources available to them. Especially in this case, like, how much money do you think that they put into this case? But they can't find something. They're not looking for it. They are busy looking on Twitter for keyword searches to implicate somebody based on a tweet, based on verbiage on a social media account. But they're not doing good research, and then they argue it both ways. And then Fletch, I think dealing with the response for the bond, I think the issue is the state hasn't responded to those renewed motions for bond. And then let's see. Anthony, I don't know how they look white, because first of all, this lighting is what it is, but the amount of coffee and tea I've started drinking since I started working on my own and having my own clients and then starting to do YouTube videos. I drink so much caffeine, you guys. So I don't know. I appreciate that. And then what do we got? Wait, Florida? The Peter Griffin? The Cohag? Okay, you know what's funny, guys? My mom, I was born in Queens originally. My mom has a Brooklyn accent, and she sounds like Fran Drescher. So that's probably where I get the little voice garble. I talk a lot and lose my voice doing these streams, but it's also in my mom's line of the family to have this kind of nasal to the voice. But her voice actually, she sounds like Fran Drescher. So there you go. There's a fun fact. And then let's see, where is, maybe we have that witness list. Let me check the drive. I don't know if ThuggerDaily, he or she. I don't see any one of these being a witness list. Maybe is this it? This was July 10th. And I think this was from the defense. Let's see. Yeah, so this one was from the defense. No, so I don't know. Yeah, I don't know. That might be it. That might be it. Oh. So, okay. Hey, ThuggerDaily. Thanks for the update. But, okay, so it wasn't filed, but in the document, in the one filing from Brian Steele, well, let me say, which one was it? We looked at the first page, and it said that they filed something on July 26th, which would have been late, right? That's late. They should have filed it on Tuesday. Let me see which one that was. I think it was this one, right? So, where did they say it? Yeah, on Friday, July 26th, the prosecution provided a witness list with an attachment declaring exhibits. So, is this something that's also not e-filed? Right? Do you think so? It's not attached. State never actually formally filed it. And if they did, I mean, I guess maybe they wouldn't file it if they, do you think they're going to assert that there's some safety concerns with witnesses they want to call still? So they don't want to file it into the record. That could be one consideration. But yeah. And thank you, Awesome, on that. I don't know if you were in here. We were talking about the Google Drive folder and everything like that. I don't know when you joined in, but everyone was like, that's awesome. That's so good. So we had shared the link to it somewhere in the chat. It might be lost by now. Oh, Nismi, that's okay. This is my first super chat. Why won't it type right? I think if you're on mobile, when you're typing a super chat, it gives you like a stupidly small window to type in. Don't roast me. We won't. I promise I can spell. Wanted to show my support. Love your channel, Cat. That's so sweet of you. Thank you so much. Let me make the screen smaller. And then, yeah, no problem. I mean, ThuggerDaily. Oh, wait, we're calling you the honorable Twitter account, ThuggerDaily. Should we call you the honorable X account? I think it's funnier that we say the honorable Twitter account. Like, just act like it's still Twitter. The honorable Twitter account, ThuggerDaily. And then, yeah, everyone's so appreciative. It's like up and down here. There we go. Look at all that love. By the way, Casper Ghost, I love the name change. And I don't know what accent I have either. I had moved in upstate New York for a little bit and I picked up certain things, like they say bagel weird. I don't know, like sometimes the upstate New York accent comes out a little bit. And then I moved down here, so. And yeah, so tons of love for ThuggerDaily out here. But what else, you guys? I think that's everything. I think we're all caught up. Unless something gets filed at 11:22 p.m. tonight. Yeah, I feel that. The only reason, I mean, I use X for other things, but I can imagine I've seen a lot of people that look like they created accounts in relation to this trial to be able to go on there, look at news and quick updates. Probably 99% because of ThuggerDaily's updates. So, and then, oh, thank you so much. That's such an honor to be the first super chat. So, Torres Hughes says, this is also my first super chat. Yeah, I definitely don't think I have a Jersey accent. No shade, though. And yeah, you guys are welcome. Shout out to the honorable Twitter account, ThuggerDaily. We're all caught up, guys. I'm 80% sure. Oh, sure. I'm 80% on doing a live stream tomorrow for the hearing. You might just see me in other people's chats tomorrow, but you'll see an announcement if I'm going to go live for it. I do think my schedule's clear, but I'm a little nervous about someone needing kind of big help. So one of my clients is in real estate, and NAR, there's been a big lawsuit hullabaloo with the DOJ for, like, it's been playing out for months and months and months. But they have a product that, you know, people can go in and make offers transparently online. It's not that different from a regular listing. It's just online and transparent. It solves all the issues the DOJ wants to solve. So they're really in grind time to get this thing out the door and launched properly and get people to know about it before this major NAR change on August 17th. So I told them I was taking tomorrow off. I wasn't going to be available, but it might be important enough that I can't commit 100%. You'll see a notification tomorrow if Kat's going to go live to stream the Judge Whitaker hearings. So maybe see you on my screen in my chat tomorrow. If not, you'll see me out in the wild. And then Drea said, yeah, early night for me. Yeah, get some rest, Drea. Thank you so much, Red Bunny, for the super sticker. I appreciate you guys, all of you. If you're bored waiting for tomorrow, I do have a 6-part series up on the Sean Williams cases. That's in Johnson City, Tennessee. It's an alleged serial rapist with over 50 victims that Johnson City seems to have covered up. And we just got through to present day, where they're introducing bank statements into discovery, showing that his business partner was making $2,000 payments to police officers, and police officers may have been protecting this business partner in case, you know, putting patrol cars outside her house and stuff like that. So, crazy story, hasn't made headlines. Crazy story, though. I did 6 parts to catch you all the way up from the beginning of it to present day. And sometime this week, after this YSL stuff, we're going to take a look at his first trial where he represented himself pro se. So that'll be fun. Pro se litigants are always fun. That's all I've got. You guys, thanks so much for joining me. See you tomorrow somewhere. Have a good night, you guys.